Hi, everybody. I think we're all on and live. My name is Alex McCallion. With me is John Ross. As you can tell, we are here today to talk about how to handle project delays. For those of you who don't know, I think everyone does, John Ross is the executive director of the Builders Exchange and is also a longtime practicing attorney with decades of legal experience specifically in the construction area and handling project delays for his clients and assisting them through this process. So John is here as a very valuable resource to help you guys both in this presentation and if you have any questions, it's a nice resource to have over at the Builders Exchange.
Thank you, Alex. And this is the second in our series of legal webinars. We'll have another one towards the end of the month, so keep your eye open on that date. And without further ado, go ahead, Alex.
All right. So for those of you that don't know me, Alex McCallion, I'm a member at Brennan, Manna, and Diamond. It's a law firm. We've got offices, about 75, 80 attorneys, offices around Ohio, Florida, Arizona, and we're licensed in most states. And if we're not licensed somewhere, we have attorneys that we partner with in those areas. So my practice specializes, I'm heavy in the construction area, both pre-suit, helping clients with contract negotiations, and if lawsuits or arbitrations are filed, representing them in those areas as well. But here we're talking about a very specific area, and it's how to handle project delays, which I'm sure all of you have experienced and may be experiencing right now. So what we're going to talk about over the next approximately 30 minutes is basically identify who impacts project schedules, what factors cause those delays, and then how you handle them. So for the people, it's basically all your project participants are going to be the ones that can cause delays. First off, you've got your architects and engineers, and there's a variety of ways that architects and engineers can cause a delay. It can be from poor design on the front end or an incomplete design on the front end, which sometimes you won't catch those delays or those errors until the middle of the construction project. Sometimes you catch them early on and it delays your start date. Another way that for those of you that work on bigger projects, if you've experienced architects, engineers with slow delay times, response times on RFIs, so requests for information, if they're not responding quickly to you, it can delay you in the field. Another one that can cause delays, owners. So delayed approvals by the owners or the owner's rep. So oftentimes it's not the owner themselves, it's the owner's representative who's causing these delays. Or excessive changes throughout the project. As you all know, if you change a project midstream, the ripple effects will flow through. Construction managers also can cause delays. So this can be from poor scheduling to having unachievable schedules, poor management, poor project coordination. There's a host of kind of generic terms that we can say, but there's a lot of pitfalls with a poorly managed project. And then of course, contractor. So contractor might put an unachievable bid in, just hoping to get the work, knowing the whole time that they can't meet a specific schedule, specific pricing. Could be poor performance or labor issues, labor shortages, or just an outright default by a contractor or subcontractor. All of those are the players, any one of which can cause a project to grind to a halt.
Just a comment too, Alex, with regards to the design professionals and what you mentioned with perhaps a slightly poorly designed project resulting in many RFIs, particularly in some public projects such as schools, where there's a very tight schedule. Schools got open, right? So if there's multiple RFIs, many, which I was involved in a project, they don't want to give a delay. So what effectively happens, that can happen to you, is that the project is going to be accelerated. Really, there's delay where there's, let's say, 800 RFIs. Okay, there's going to be a delay, but the owner, the public authority, cannot effectively grant an extension of time. So your project could be accelerated, and that's something to think about, which can result in a claim for you if you've got to accelerate your work. So it's a consequence of delay, where sometimes the owner is effectively going to accelerate it because they won't grant you a delay.
Yep. And John and I probably both dealt with that. I had one, it was a project for NASA that had over 450 RFIs, and NASA was the owner, and they just would not grant any type of delay damages until the end. And we had to go through the full arbitration process before they would finally admit that it was the excessive RFIs and the delays by the architects and engineers and responding to those that caused an accelerated schedule and increased costs for both the general and all the subs all the way down the line.
Interesting.
So factors that can cause delay, very similar to the people who can cause delay. I'm sure most, if not all of you, have seen these out in the field. So you've got your environmental. I think it's raining today. So you're going to have rain delays. Rain can cause a soupy, muddy mess if you're early on in the project. You've got what we don't experience as much anymore, but winter conditions always slow things down. And then there's management factors, site factors. Unsuitable soils are always a fun one that kind of dovetails back into the presentation we gave a few weeks ago about contracts and the various clauses that you need to look out for. And site factors is a big one, and whose responsibility it is to be aware of those site factors. Similar to what we just talked about too, manpower and economic funding. So if you don't have the workers and you don't have the money, it's going to be hard to get a project done on budget and on time. So those are all things that could impact your scheduling.
Well, manpower and the lack thereof may be a topic for another day with us here, because that's certainly a factor in making contractors' performance difficult. You know, it's not quite what we're talking about here, but it's certainly an issue that is out there today for our contractors.
Yeah. More factors in detail on the management factors. I think you all can read the slides, so I don't need to go through them one by one. But any one of these things, from inspection to stop work orders to poor scheduling, are just more things that can cause delays. And one important thing is there at the bottom is that a lot of people when they put schedules together, it's your base case scenario. And when they do their critical path analysis, they do not build in time or enough time for contingencies and factors that naturally come up in every single job. So if you're working off of a best case scenario for your project schedule and anything happens, all of a sudden you're trying to make up time and you're going to have a faster schedule moving forward. So that was a very quick overview of the items that can lead to a delay. And now what we're going to go through are the steps on how to handle them. And John and I are going to give you a few examples along the way. So the best thing to do, which is this, it's a lot easier for me to sit on a webinar and say this than it is for you guys to do it in the field, is to expect delays. So if you assume going into a project that something is going to happen and you are ready for that, it will make life a lot simpler and less hectic than if you encounter a delay and you don't know what to do. So few examples. Oh, go ahead.
Oh, I was going to say, you have to know your contract, right? And what you're required to do under your contract in the event a problem arises and you are delayed. That's essential that you do that you know your contract.
So know your contract, know your schedule. As I mentioned, build in contingencies. You need to know you're on a larger project. Hopefully you have a critical path and you're using the software to develop your critical path and have timelines where you can catch up if needed, and then be able to know what is the new critical path along the way. An example of an unexpected one I'm dealing with right now, an unexpected event that could be fixed had people thought about it ahead of time. The engineer and architecture firm assigned one person to a project. That person's had a death in the family and disappeared for 3 months. The architecture firm had no backup that was familiar with the project to keep it on schedule. So everyone is left, when they have RFIs, they have issues on site, there's no one to go to. Ended up delaying the project by months. Had the project participants thought of that issue ahead of time and made sure that there was a backup for an architect or an engineer if they went out, or backup for other people, then it would have headed off this issue. And that's one of those things that sometimes you learn by experience, that you need to make sure that you have 2 points of contact with your engineer, not just one, and things don't get lost in an email inbox.
So we'll get to it later on in the presentation. It kind of goes back to our first webinar regarding damages. And, you know, again, notice is critical. When you see you've been delayed, protect your rights. You shouldn't offend anybody by doing so. I mean, this is business here, and you're simply protecting your rights that you've been delayed. And I think when you get into a real dispute or an argument, the design professionals almost all the time will try to maintain that whatever caused the delay wasn't on your critical path. So you're going to have that argument, right? Almost all the time. So be prepared for it, right?
Yeah. So as John mentioned, and we'll get into it, it's your typical AIA contract is going to have a clause that the architect or engineer is the initial decision maker. Well, what if the delay event was caused by the architect or engineer? It's going to come up, and you're just going to have to work with it. And eventually, basically, you just follow the contract, put everyone on notice of the issues, and then deal with it when the time is right, whether that's through arbitration, litigation, or direct negotiation with the owner. But oftentimes the person you're dealing with about a delay event is the one that caused it.
Yeah. So with the AIA, as Alex mentioned, the standard AIA form will be that the general conditions is that the architect is going to be the initial decider of any claims. And, you know, in a way there's a little bit of inherent conflict if it's the design professional themselves that are the source of the alleged claim and delay by the contractor. Okay. They're not going to raise their hand and say, yeah, it was us. We screwed up here. That's not traditionally the case here. So, you know, so sometimes, and it hasn't been a real great experience with me where the owner is in that scenario where you're claiming perhaps, again, the RFI example, where perhaps designs were shipped even overseas. Structural steel design was shipped overseas, and you get all these RFIs. Okay, is the owner going to look at his design professional and say, yeah, this is your problem? It seems to be the nature of the beast that the owner is going to be more a little friendly, a little cozier with the design professionals than with their contractors. Unfortunately, that just has been reality. Yeah. Not fair, but
yeah. To John's point, I have one right now where the owner basically said, okay, well, if you're blaming the architect, you go ahead and you file for arbitration against us, and we'll pass it through and tell the architect, hey, they're blaming you for this, and isn't willing to work with us beforehand to try to rectify the issue. They're basically saying, hey, we're not getting in the middle between you contractor and you engineer, architect. You guys basically just fight it out in arbitration later and keep us out of it.
Yeah. Huh. Well, also, one thing you should be careful of when we say, you know your contract, is that, again, going back to the AIA, if that format is used, make sure that the AIA has not been modified, because it can be modified, and it is modified many times. So you got to look at the whole document there.
Yeah, and if the person who's drafting it is being nice to you, they will underline or redline the changes they're making to the standard AIA contract to point them out to you. If they're not being overly friendly, you have to read the whole thing and see where your potential pitfalls are. And I'll get to that a little bit later. I have another example where on timing and notice, where the owner did modify the AIA and modified it significantly to shrink your notice period.
Right.
So one of the first things to do when you experience delay is to perform a delay analysis. So hopefully you have software to help you with this, but you figure out your baseline schedule, or hopefully you've already figured out your baseline schedule. You know where your critical path was. You know where your as-built is. You compare them. Hope you have software that can help you with this, but that will help pinpoint the delays for you, where the areas are. And the trick when doing this is don't do it just for the sake of doing it, is to figure out a theme or a contractor or figure out what is actually causing the delay. And it may not be what you think until you do this analysis. There may be a contractor who's a complete pain in the butt, or you think is not on schedule, but it's actually someone else who's pushing their work back. So using the software and the as-built compared to the baseline schedules is going to help you with that. And then once you figure out the causation of it, then you can move forward with figuring out how to fix it. So this is what John was talking about, the contract requirements. Almost all your AIA contract and almost every contract that you guys sign, whether that's in your specific subcontract or if it's in the general conditions of the prime contract, which are always 99.9% of the time are going to be incorporated into your contract. So even if you don't see it in your 5 to 15 page contract, there could be dozens or hundreds of other pages out there from the prime contract and the general conditions that have been incorporated into yours. So this was the example that I was going to give. It was an AIA contract on a public works project where the general conditions that our client, I don't believe ever even read because they were just incorporated by reference, were modified to say that if you experience a delay event, you have to verbally notify the architect within 2 days and put it in writing within 10 days. And on top of that, a different provision said that the writing somewhere else in the contract said that the writing had to be by certified, registered, or FedEx. So it's not enough to email them and say, yes, I put it in writing. It's not enough to hand them a letter. You actually have to have proof that you notified them. And where this becomes extremely important and nearly impossible in this case is that oftentimes 2 days in, you don't even know it's a delay event.
Right.
It could take 3-4 weeks before you realize that some plumbing mistake or an HVAC being delayed is actually causing a delay to your whole project. So if anything, it's important to know those and communicate them as often as necessary. It's always better to over communicate than under communicate. And when we say communicate, you don't have to point the finger and say, hey, this electrical subcontractor is not doing their job, or you architect are not doing your job. You can just put the facts out there transparently and say, we experienced this event. We think it's causing us a delay. And then everyone is on notice of that issue. And in an ideal project and through your project meetings and your weekly meetings, you will work together with the subs to figure out, all right, is this really a delay event? How big of an impact is it going to be? And then how do we fix it?
So what, with such narrow timeframes in the contract documents requiring notice to the owner or the design professional, they're somewhat setting you up for a defense to a claim by you if they're delayed, right? You didn't give us adequate notice, but you got to make the argument anyway that you gave it notice within, to your example, 2 days, which is, I find ridiculous, but you can make the argument that, hey, we gave you notice within 2 days of us discovering that we're being delayed for these reasons. So that's the arguments that you'll have to make. But it's also nice to, it's nice to know what's in the contract documents that are proposed before you sign the contract, okay? Because you can look at it and say, okay, is this really going to work? Is it negotiable? And if it's not, okay, then I guess we're going to accept, this type of burdensome contract or not going forward. But again, it's nice to know upfront before you sign the contract rather than just taking the job. Also, if the owner and prime contractors contract is incorporated into your contract, then you have an absolute right to get a copy of that contract from the owner or the party that you have a contract with. So you many times ask the prime contractor for a copy of their contract with the owner if it's incorporated.
Yeah. And there's a question here is how do we handle project delays as a sub if the general is causing the delays? So first thing, go back and look at the contract, Because sometimes, actually oftentimes, it's not enough just to notify your general. Because the contract may say the actual person who needs notified is the owner's rep or the architect engineer. So, and when I say look at the contract, I'm not saying look at your contract with your general, just your contract with your general. If you're the sub, you have to look at the prime contract and the general conditions of the prime, because those will flow down to you. So if you, obviously the best thing is to look at them in advance, but if you don't and you experience a delay event, you immediately need to look at those, the prime contract and the general conditions, to notify the right people. Otherwise, you might be shooting yourself in the foot and waiving your claims down the road if you only notify the general. Because then eventually the owner's going to say, well, we didn't know about this. You didn't tell us. You told your general, who didn't tell us. So it's not our fault that you were delayed, and we're not giving you time or extra time, extra funds, increased materials, whatever it may be.
And this is a common problem too. So this is it's not unusual.
Yeah. And don't be worried about the awkwardness or the ruining the relationship because you want to get another job from this general if you're the sub, or if you're the general and you want to get another job from this owner, because it's just as important to protect your rights as it is to maintain that relationship. Because when a project goes sideways, it could be your best friend, but they're still going to be finger pointing at the end of the day when it comes to dollars and cents. And you don't have to do it in an aggressive manner, but you still need to do it just to protect yourself.
This is where finger pointing can start too. When you put your general contractor or your construction manager at risk on notice that you are being delayed, they may be passing that delay problem onto either the owner or the design professional, saying, no, it's really these guys. And so that's when the story starts, really.
Yeah. And then it could make for a sticky project for the rest of the way, but it's still better to put everyone on notice so that everyone knows that there's issues, rather than wait until the end and
Right.
people claim that they're surprised by issues.
Yeah, it's protecting your rights. That's
Yeah.
what it is.
Yeah. And these note to John's point about waiving claims without the notice, there's all sorts of claims waivers in the contract, like we talked about in the killer contract clauses, all the different types of damages you can waive, or just waiving everything in its entirety. So you could be stuck with liquidated damages flowing down to you because you didn't notify the proper parties in time that it was not you causing this delay, and someone else is the reason that you are 30, 60, 90 days over your allocated time to complete your portion of the project. So final substantive slide is, so you've identified the issues, you put everyone on notice of the issues. Well, then what? This is probably the hardest part, is execute a recovery plan. So identifying a new critical path is not that difficult. It's the second point on this slide, which is obtaining buy-in from all the parties. So if your other subs, your general, your material suppliers can't keep up or cannot meet whatever the new critical path is, you're wasting your time. So I've got one where a school project that went bad that I'm working on, where the actually a scheduling expert came in, identified a recovery schedule that was so ludicrous that everyone ignored it. And a new recovery schedule was put out every single month that would show people tripling, quadrupling their manpower, stacking sub after sub after sub on top of each other, that it was just impossible. So no one bought into this recovery schedule. No one tried to work harder. I think at the end, the project was delayed about 2 years because there was no buy-in. Everyone just said, no, that's not realistic. We're not going to go bust ourselves for this. So,
and they may have been right? Your position was, yeah, this recovery schedule was, by the scheduling consultant, was bad, right? Yeah. So, yeah, then the problems become multiplying and real bad. So many times when the project is delayed, Alex, will not the design professional ask the prime contractor to put together a recovery plan? And so he's got to and instead of the scheduling consultant who's coming on board, they may just ask the prime contractor, okay, we need a recovery plan here. How's this going to work? And they have to devise one with all the subcontractors, okay, which is a significant task, obviously. So, and many times, unfortunately, when projects do go bad one way or the other, and with delay, you're going to have to, it becomes the battle of the experts in some ways if it goes legal. Let's see, we've got another question here.
The question that's being asked, how do you handle if your payment is behind and because of that, you're going to pull off the job? This is an insanely tricky question that goes back into the contract language, because oftentimes you are not allowed to pull off the job. And if the contract says if you pull off the job, you are now in default. So it's kind of a catch-22 on you.
That's the nuclear option for the contractors, is what really it is. When you say, okay, I'm going to pull off the job, I'm done. Okay.
Yeah.
I can't afford to invest more of my time and resources into this project when it's questionable that I'm going to get paid.
Yeah.
So that is the nuclear option there that you have.
Yeah. And if you ever pull off a job because you're not getting paid, be prepared that if another sub comes in and does your job for you, that your general or your owner is going to come after you for whatever that cost difference is. And somehow miraculously, it's always a lot more to do the same work that you were contracted to do when someone else comes in. So that is definitely the nuclear option. And this is why subcontractors often get put in a bind, is because you may not have the cash flow that a general does, and you are eating these costs knowing that it could be months or a year or more until you get paid, because there are avenues to protect yourself, but they're not efficient avenues. So we can file your mechanics lien for you, but that's not going to get you paid right away. We can file your bond claim for you. That's not going to get you paid right away. So there are mechanisms to protect you to make sure you eventually get paid. But if you're in a cash flow crunch because you've submitted 6 pay apps and it's been 6 months since you've been paid, you're in a bind.
Yeah. So what the threat to pull off the job can be is effective leverage, right? Because I'm sure the owner nor the prime contractor is going to want you to pull off the job. And so, that can be leveraged, and when projects go bad, that's a common threat in your arsenal, as well as Alex mentioned, filing of a mechanics lien. That's it too.
So yeah, because the mechanics lien can serve multiple purposes. Yes, it does protect your right to payment, but it also can interfere with the project funding if there is a bank involved funding the project, where the bank may not release funds until your lien is taken care of, or may do something else to halt the project. And if it does get bad enough and it's a big enough project, making a bond claim, or if enough subs make bond claims, it could cause the bonding company to step in and take over the project, or take over the payment aspect of the project to make sure it does get complete on time and the subs get paid so that they'll keep working.
Yeah, and going back to the killer contract clauses webinar, and one of those clauses that we mentioned in there is no damages for delay. They still may have that clause in your contract. The owner still may put it in there, or even the prime contractor. That clause is invalid in the state of Ohio. Just be aware of that. So don't get misled by not putting in a damage claim if you're delayed because you have that clause. That's unenforceable.
Yeah. So what you'll see is, through all the other clauses in these insanely long contracts, they'll know that they can't pick away at your no damages for delay. So they try to attack it in other ways by limiting your damages, having consequential damages waivers, putting in these insanely tight notice provisions. A lot of that is done with the goal of picking away at your rights for delay damages. So you can still go after them, but you got to really follow the contract terms to do so. Yeah. And before you ever walk off a job, if you look at the contract or you don't think you have all the contract, call your lawyer or your advisor, whoever that may be, to work with them to come up with a plan that complies with all your contractual commitments, puts people on notice before you just walk off and say, I'm not getting paid, I'm out, because that may do more harm than good at the end of the day.
Yeah, when you go with that the nuclear option, as we call it, you have to be very confident that at the end of the day, you're going to prevail. Because if you're wrong, they bring in a replacement contractor, they're going to back charge you, they're going to offset, and that can get ugly.
And that's the end of the presentation. The key takeaways: delays are going to happen. Do your best to work with them, notify all parties, work with the other project participants. The better everyone can work together to fix the delays, the less you're going to have to call John and I after the project is over to do the finger pointing part. So recover as best you can. And as long as you put people on notice, you can still keep going forward with the project. You don't necessarily have to have those knockdown, drag out fights where you're screaming at each other during the middle of the project over a delay. Save that for the end. Once you get the thing done, then you can have the arguments over whose fault it was, who's entitled to increased compensation, and whose fault it really was. So it is all right. It's 11:30, so our presentation is over. Yep, someone read my mind. When should you get your lawyer involved? Do you want this one, or you want me?
Well, I would say, hopefully you have a good relationship with a lawyer that's familiar with construction law, and the sooner the better. From our perspective, from the lawyer's perspective, just let us know what's going on, and a good construction lawyer is not going to exacerbate the problem right away. Kind of give you some good advice. Hopefully you resolve the matter, but we also don't like to be called, when the problem is significant and events have already happened which could have been prevented.
Yeah. The longer you wait to call us, the more expensive our bills are going to be. It's really what it comes down to.
That's true. Yeah.
So if you're not familiar with your AIA contracts, or you're new to the public contracting space, get a good construction lawyer who can help explain it to you, who's not going to say, I need to look at every single one of your contracts and charge you thousands of dollars.
Right.
Get someone who can work with you to explain the clauses so that you know what to look out for. And as you get comfortable enough with them, you will be able to read the contracts yourself and say, oh yeah, I know that clause. I know that clause. Hey, we can negotiate this one with this prime contractor. We've done it in the past. So then you know what you're doing on the front end. And then as issues pop up, a quick phone call to your lawyer to say, hey, here's the issue. How do we deal with it? Is going to help you tremendously at the end of the project, or in the middle of the project, and saving on legal fees and having to file for claims and getting into a big dispute.
Yeah. No. That's a good one. Well, yeah, well, a little bit of tongue in cheek here at the end. One of our folks said, do you know any good lawyers I can call? So that's why I said no, but as we're just joking here.
Yeah. So for better or worse, we'll shoot you all an email with my contact information and John's contact information. So for those of you who don't already have a good construction lawyer, you can always call either of us.
And I can guide you to somebody that knows that area of law that pertains to your problem too. Yeah,
because there are numerous issues that come up. This is off topic from from what we're here to talk about, but both in your construction space, your union contracts.
Right.
John is a great resource too. If he doesn't know the answer to your question, to point you to lawyers that specialize in that specific area. So it can be there's pension issues, contract issues, construction. There's all sorts of stuff that can impact your business. So having someone like John is great, where he can tell you where to go to find your answer, and with a lawyer that he trusts. So that's just as good.
So, and if there's topics that you would like to have addressed in a legal webinar presentation, or in other areas of professional advice, I suppose, email me at my Builders Exchange email address, jross@mybx.org, and we'll take a look at it here. We have another presentation webinar at the end of the month here. And we'll be giving you notice of that. We already did, but we're thinking of moving it from March 28th, I believe, to March 27th, which is a Wednesday. Talk with Alex about that, but you folks will get and it's about OSHA, correct?
Yes.
Okay.
So, yeah, we try to do these on topics that you will find interesting that you're not already experts in. We could do these on mechanics liens all day long, and either you know them or you're going to call a lawyer. So me telling you that you have 60 days or 90 days to file a mechanics lien is probably going to go in one ear and out the other. So then we try to do topics that you guys will find interesting and helpful. So the next one is on OSHA. And as John said, if there's something that you want to hear from a lawyer on that you don't know about, let us know and we'll try to put together a presentation on it, something quick and easy like this, 30 minutes in and out, and you're back to your day.
All right. Thank you, Alex.
All right. Thank you, everyone. Any more questions before we hop off? All right.
Okay.
Either no questions or you guys can't type fast enough. So we will call it a day. Feel free to email us if anything else comes up you guys need.
Thank you. Have a good day.